For 800 years, people had stepped into docks knowing that they couldn't be tried for the same crime ever again. If they were cleared in a courtroom, that was it. The courts are underpinned by very important principles, and they don't change those values lightly. But the Stephen Lawrence case gave fresh impetus to the debate about the ancient law of double jeopardy. In 1989, Julie Hogg was murdered, her body hidden under a bath in Teesside. Her ex-partner was cleared, but later confessed to Julie's killing. But the law meant he couldn't be prosecuted again for murder.
It was right that the law be changed, to give the chance, if there's been a proven wrongful acquittal, for that person to be retried. And the safeguards are so stringent, there's one chance at a retrial and one chance only.
Billy Dunlop then became the first man in England and Wales to be convicted second time around. Julie's family had campaigned hard for the law to change. They'd fought for justice. It would have a big bearing on the Stephen Lawrence case. In 1996, Gary Dobson was among the suspects privately prosecuted by the Lawrence family, but the case collapsed. The change to the law in 2005 meant it was possible for Dobson to go on trial again. Only a few cases have been affected so far, but now that the laws have been changed, very careful consideration must be given to each one. In short, the new evidence must be a game changer. The fibres and blood found on the clothes linked to Dobson reached the required threshold.
When science, years later, produces irrefutable evidence of someone's guilt, then that someone should be brought to court and asked to explain it. And if that evidence stands up, if it hasn't been contaminated by incompetent police work, then I think society can at least be reassured that justice has eventually been done.
It was DNA that eventually caught up with Mark Weston. He was accused and cleared of murdering Vicky Thompson in Oxfordshire in 1995. But a speck of her blood was only found on his boot years later.
When we got the judgment from the appeal court that it could go to a fresh trial, we were delighted. I actually felt that was probably a more difficult hurdle than the actual trial itself, because I thought once a jury hears this evidence, they're going to find him guilty.
But when someone stands here in the dock, there is a presumption of innocence until proven guilty. Some critics of the change argue that because someone else effectively judges the new evidence beforehand, it's harder to get a fair trial. The legal profession, though, insists that the whole ethos of these places is to achieve fair justice, whatever the circumstances. Tom Parmenter, Sky News.